But thank you all for being here. We'll see if we still have some more people trickle in. I know evenings are really hard. I really like presentations in smaller groups because it gives us a chance for you all to ask questions. So please feel free to ask questions as they come up. My name is Sarah, this is Angie, and our presentation's on dispute resolution options for K through 12 students with disabilities. Our presentation is very wordy. We didn't follow the rules on not putting a lot of words on the slides, but that's because you're going to receive the slides and we want you to have the most information possible. So don't worry about having to read and soak in everything that we're saying because we are going to give it to you later. Before we begin, can I just know who's in the room? So do we have parents in the room? Cool. Educators or school staff? Great. Other, I guess, advocates, attorneys? Awesome. Law students? All right, awesome. Thank you so much. That's super helpful. So, like I said, I'm an attorney at Disability Law Colorado. I do primarily all of our youth advocacy work as well as our voting rights work. And then Angie is a senior advocacy specialist. So when you do an intake with our office, she might be one of the lovely people that you get the pleasure of speaking to and kind of navigating the different issues. The reason that we put on the presentations like this is because in the education space there are so many complaint options and options that parents have, and no one knows where to go and what to do, and so we want to try and parse that out for all of you in the best way we can. That being said, some complaint options are maybe going away or not as effective right now, and so we'll kind of talk about that a little bit too. But all that being said, we'll begin. I'd also like to shout out Denver Human Services. They support our work and let us do presentations like this. So if you are a person with an intellectual or developmental disability in Denver, or if you have a family member who is a person with intellectual or developmental disability in Denver, please scan this QR code and take this survey so to help them better know how they're reaching that community. QR codes are also in the back if you already missed that. But I'll pass it over to Angie for a little bit, and then I'll be back to talk to you later.
Hi, thank you so much for coming out tonight. I never know if I'm yelling into these things or not. So wanted to talk a little bit about our agenda and who we are. Disability Law Colorado. We are Colorado's protection and advocacy organization. There is one of us in every state. We also have a main head organization, the National Disability Rights Network, and we help promote and protect the rights of people with disabilities throughout the state of Colorado. The next thing we're going to talk about is the importance of this topic, and I apologize, I went a little too fast on my slides here. So Disability Law Colorado. Like again, we're the protection and advocacy organization for the state of Colorado, and how we protect and promote the rights of people with disabilities is through policy work, training and presentations like the one we're doing tonight. We also work primarily doing systemic advocacy, where our work can sort of change things for a large group of people with disabilities, and because of that we don't take on as many individual cases. We do still do that. Our individual advocacy is usually centered around information and referrals, technical assistance, and self-advocacy assistance, which is sort of where I work at DLC. I primarily work in that role, and I specialize in the education area. And we sort of figure out what we're going to do for the year based on our annual priorities, and towards the end of the summer, beginning of fall, you'll see something on our email addresses or on our website letting you participate in a survey that tells us a little bit more about what Colorado residents feel like we should be taking on. All right, so why is this important? Everything that we're going to talk about tonight. Like Sara was saying, there's so many different processes and different jurisdictions, different laws and deadlines for filing complaints. There's different requirements for filing complaints and different requirements for opening an investigation, and what might be right for the IDEA might not be the same method that you would use for filing a complaint under Section 504. There's different processes for investigating claims, different timelines for decisions, and potential remedies for each type of complaint can be different based on, you know, what you can ask for at that time. So is this you? Okay.
Okay, so talking briefly about the legal landscape in the education space, and then I'm also kind of going to give a brief overview of special education topics, because I imagine you all aren't super familiar with every in and out of the legal world of special education. However, I'm not going to go super in depth in that. So if a lot of this beyond this goes over your head and you want more information, I'd recommend our education resource guide, or feel free to reach out to our office too. But I do want to kind of give an overview of what we're kind of working with. So in the special education world, we're working with some federal laws and some state laws. So the federal laws that can apply are the Americans with Disabilities Act, Title II, so that applies to public schools, or really all government public entities. Title III can apply to private schools, so they apply to places of public accommodation, places that hold themselves out to receive services, such as private schools. They have to comply with Title III of the Americans with Disabilities Act. Section 504 of the Rehabilitation Act is also really important. This really just prohibits discrimination against people with disabilities. Title VI of the Civil Rights Act prohibits discrimination on the basis of race or national origin, and Title IX is the prohibition of discrimination based on gender. So what's really different, I would say, about the ones I just said versus the Individuals with Disabilities Education Act is those are civil rights laws. So Americans with Disabilities Act, Section 504, Civil Rights Act, those are all civil rights laws. So they're really protecting your rights as a person. But the Individuals with Disabilities Education Act is different because it's an entitlement law. So not only does it protect your rights, but it also bestows rights upon you if you qualify under the Individuals with Disabilities Education Act. So these laws above are pretty broad in how they define who they protect. The Individuals with Disabilities Education Act, I'll call it IDEA for short, you have to have 13 very specific categories that you would fall into in order to receive services under that law or be protected by that law. So that's kind of the difference on the federal level there. State laws, the Colorado Anti-Discrimination Act. So the first 4 laws there, basically it's the discrimination law at the state level. So if you feel that you're being discriminated against, yes, you have the ADA and you have the Civil Rights Act, but you also have the Colorado Anti-Discrimination Act if it's an entity within Colorado. I would say sometimes its protections go above and beyond some of these other laws. It can't necessarily take rights away. So for example, the ADA underemployment might apply to employers that have over 15 people that work for them. Under the Colorado Anti-Discrimination Act, that can apply no matter how many people work for you. So it can add additional rights, it can't take them away. The next law is the Exceptional Children's Education Act, and this is basically the IDEA, but at the state level. They say almost the exact same thing, but it can be helpful to both enforce federal and state law if something has gone awry. The last one is the Protection of Students from Restraint and Seclusion Act. This just got a little bit of an overhaul and name change, so you might also know it as the Protection of Persons from Restraint and Seclusion Act. But nothing really changed, it just got moved to really apply to public schools because other agencies where restraint is allowed, all of the laws were kind of intermingled and it was getting confusing. So now it's the Protection of Students from Restraint and Seclusion Act, and that's very specific to Colorado, and that gives rights and I guess different things that you have to do around restraining or secluding children. So it distinguishes time limits for when something counts as restraint and seclusion. It distinguishes what the documentation needs to look like. So it's really important for parents, if their children has been in an incident of restraint and seclusion, to make sure that the school is following all of the procedures laid out in that law. And we'll get to this later, but there is enforcement mechanisms at the state level for this law, so it does have some teeth to be able for students to be protected. Special education basic concepts. And again, I'm not going to go into a lot of depth about this, but that wonderful packet has more information. But these are just kind of, I would say, the building blocks of special education. So special education, as I said, is an entitlement law. What does it entitle you to? It entitles you to a free and appropriate public education, or FAPE. And that's something that every student with a disability who qualifies under the IDEA receives as a free and appropriate public education. It has to be free to the student and to the family, and it has to be appropriate to that individual's needs. So the individual piece is really important. Where do you receive this free and appropriate public education? In the least restrictive environment. So the important pieces to know about least restrictive environment are that placement does not equal location. So if a district wants to offer placement to your student, they don't necessarily have to offer that in a specific building. There are kind of gray areas on kind of what they have to consider, but they don't have to say it exists in this specific place. You want your kid to go to this specific school, they might be able to offer services somewhere else, so that's important to keep in mind. The next thing I have on there is continuum of placements. The really important thing to keep in mind is there's a whole continuum, right? So there's least restrictive placements and there's most restrictive. So most restrictive would be a student who's receiving like care in a hospital, who's receiving their school education in a hospital setting. Least restrictive would be a student who's in the general education classroom all of the time, and then there's a whole continuum in between. What you should keep in mind there is they're not supposed to make big jumps from that. So they shouldn't be saying, oh, this kid is thriving 100% in the general education classroom. Now they need to go to a completely separate school for their disability. I know sometimes they do that, and sometimes they may be able to say that, but they're not supposed to be doing that without considering less restrictive alternatives. Then child find and evaluations. School districts have the onus of child find. So they have to find students with disabilities in their district, and that onus always exists for them, and it doesn't expire. So it's not just for kindergarten. It can be when you're 20 years old. If you have a student that needs an individualized education program, they still have the onus to be able to find that student and provide them services. The next bullet is meaningful parent participation. That's exactly what it sounds like, making sure parents are able to participate in meetings and know what's going on, because all of this legal jargon can be really confusing. The next bullet there is behavior intervention plan. So if a student has different behaviors, these plans essentially talk about how the school is supposed to respond. The really important thing to remember for behavior intervention plans is that they are really important. Sometimes you might have an informal plan that says like, oh, the school's going to do this or that, but that's not legally enforceable. A behavior intervention plan is legally enforceable, and so you have additional rights if your student has a behavior intervention plan. The next bullet is manifestation determination reviews, or MDRs. So this basically says a student with disability cannot be removed for 10 or more days without a meeting convening to see if the behavior is a manifestation of their disability. If it is, they cannot be punished, they cannot be suspended, expelled in the way that the school is trying to. If it's not a manifestation of their disability, then they can be. There's a lot of nuances there, but it's a really important concept when it comes to dispute resolution. The last thing up there is compensatory services, and we're going to talk a little bit more about compensatory services throughout the presentation, but the compensatory services are a big thing that you can get from dispute resolution. So services essentially to make up for the time if a violation occurred, where would the student be if that violation had not occurred? So you hear us talk a little bit more about that. But I also wanted to note that you don't have to go through dispute resolution to ask for compensatory services. I would recommend doing it in writing always, but you can email and say, I think my child's entitled to compensatory services because you didn't provide them a speech therapist for 3 months and you need to make up for that. So You don't necessarily have to file a complaint to be able to get those. So that's, I think, an important piece to note there. So that was my very high-level overview of special education law. I think obviously there are a lot of nuances and a lot of specifics, but I wanted you to be able to have that information kind of before we talk about the nitty-gritty complaint options. And now back to Angie.
All right, so tips for improving parent participation in meetings. So some of the things I like to tell parents is, plan for the day. You want to be prepared to talk about what is working and what's not working and why it's not working. Things that were working when your child or your student was 6 or 7 years old, like stickers and games and things like that, probably are not going to work out when they're 16, 17 years old. You want to get copies of the documents and study those documents before the meeting and be able to exchange documents in advance. Another thing that's really important is don't go alone. Even if you don't have an advocate or you don't have an attorney, it is always good to have somebody there just to take notes, like just to have a support person, because it's like 5 or 6 people on one side and then it's you. And if you have somebody there, it can just be a little bit more grounding. You want to consider whether both parents, the student, and or an advocate should attend. Usually when a student gets to hit about the age 14, they can start talking about transition services, and it might be a good idea for them to attend. If both parents can't make it, or there's somebody that you really want to attend but they just can't make it, if you can get them on the phone or even participate in like a Zoom part of the meeting or Microsoft Teams, that can be really helpful too. Find out ahead of time who is coming and consider inviting others that might have knowledge or expertise. If you're, for example, going into like a manifestation determination review and you have got somebody that can speak to why this is, caused by the student's disability, and see if you can get that person to attend or write a letter on your behalf. If the meeting time doesn't work for you, it is okay to go ahead and ask them to schedule it when it does work for you. At some point, if you keep trying to reschedule a bunch of times, they may go ahead and do that meeting without you, so you want to keep that in mind, but they do need to make it so parent is able to attend. Let's see. At the meeting, ask your questions. Have your questions written out ahead of time, because I don't know if you're like me, I get nervous in meetings and then I forget to say things, so I always try to have everything ahead in front of me before I go. People in the special education world and attorneys and advocates, we talk in acronyms. We say IDEA and ECEA and the BIP and the SPED and chances are, if you don't know what something means, somebody else doesn't know what it means, and it's okay to ask, like, hey, what does this mean? It might have meant something in your old school district, and it means something completely new if you just moved into a new school district. If you've got questions about evaluations, questions about services, ask for them to be explained during this meeting. Effective communication and understanding are really important, and if you need things in a different format, if you are not an English-speaking person, you need things translated, you need things for your disability, it is always okay to ask for those things. As a parent, you are a member of the team. You're an extremely important member of the team, and parent is a word that is mentioned many, many times in the Individuals with Disabilities Education Act, so keep that in mind. Share your thoughts on what you want to see in the IEP or in the 504 plan. They don't always have to take everything you say. They don't have to put it in the IEP, but they do need to consider it. And as a member of the IEP team, you have a right to share your thoughts and what you think. And evaluations can also be really helpful at that point. Keep the focus on the unique needs of your child. Focus on what your child needs, not on, I heard that Joey down the street, he gets a one-on-one pair. Why doesn't my child have it? Let's focus on why your child needs it, not on what the other kids have. Let's see. So some final tips for parent participation. Try and keep your cool. It can be really hard because it can get emotional. It's about your kid, and it's hard. It can be really hard, especially, you have people on the other side of the table, they care about your child, but it's your kid. It's also important to remember it's a long-term relationship. If you are just starting off and your child's in first grade, you could be dealing with some of the same people for the next 10, 11 years. Make sure the job gets done. If there are people that need to leave the meeting or can't make the meeting, it's okay to ask for the, let's have a second meeting when everybody can attend. There's no reason why you can't schedule another meeting on top of the meeting that you just had. Encourage the use of an agenda so everything you want gets covered. And review the IEP or the 504 plan. And you won't necessarily, you're not going to get a copy of it when you leave the meeting, but the object is to, get a good document going. So what types of issues are good for dispute resolution processes? Free and appropriate public education. Your basic, like my child is supposed to get 65 minutes of physical therapy services per week, and they have not received anything, and it is 3 months into the school year. They're like big issues. Like Sara was talking about least restrictive environment. There's like that whole continuum of placements. They need to be going through all of that before they start looking at a more restrictive placement. Denial of meaningful parent participation. They do need to do more than just let the parents speak. They need to consider things that the parents are saying. Discipline issues are always good they come up a lot in dispute resolution. Restraint and seclusion. Are they following all of the right processes? Were you notified? Did you get a report about it? Different treatment of a student with a disability. Are they saying that your child can't go on a field trip because of their disability and they have to have a parent, they don't have anyone available? Or they're wanting you to attend because your child has a disability. Harassment and bullying of a student with a disability, specifically based on their disability, and retaliation. If you file a complaint and all of a sudden things just start going downhill, or they retaliate against you or your child based on that complaint. Those are all good things for dispute resolution. So informal and semi-formal dispute resolution options. Sort of the basic place where you really would just want to start is you start by requesting the IEP meeting or the 504 meeting. You don't have to wait for the formal like triennial or anything like that. You can always request an IEP meeting. Bring an advocate or a friend to the meeting like I was suggesting before. Communicating concerns to someone within the school, such as the school principal or the school counselor. Always important to do these things in writing. I took a training recently and they just kept pounding into us, if it's not in writing, it didn't happen, and that sort of always stuck in my head. Communicate the concerns to someone within the school district, such as your special education director. On the CDE website, there is a list of all the special education directors throughout the state of Colorado. The Section 504 coordinator, this can be someone in the school level. Many times it can be like the assistant principal, or it could be someone at the district level. They do have to have someone. They're required to have one. Another semi-formal is the district Section 504 grievance procedures, and those will also be outlined on the school's website. We're not going to spend a whole lot of time on the informal and semi-formal, but we do want to encourage parents to start here. So formal administrative dispute resolution options. So we've got the state options. We've got a facilitated IEP meeting. You can request facilitated IEP meetings, and we're going to go over this a little bit more through the CDE website. Mediation through the Colorado Department of Education. You can do mediation alongside the complaint process. You can request it without going through the complaint process. There's also the IDEA resolution meeting. There's state complaints to the Colorado Department of Education, due process complaints through CDE, and also the Colorado Civil Rights Division complaint, which is a process that's getting used quite a bit right now, just with some of the federal offices not having as much staff as they used to. Federal options are going to be the Office for Civil Rights. Again, they are operating on a skeleton staff, and don't believe the Denver office is open anymore. But we are seeing some complaints get through, so we are recommending that people still file those complaints, if anything, just to make a record. The Department of Justice, and there's also mediation alongside these complaint options. Also, if you guys have any questions about any of this, please feel free to ask for us while we can check. So the first one, the state options, facilitated IEP meetings. They are available for disputes if your child has an IEP. They're not available for 504s. They can be requested at any time, and the request form is through the CDE website. They can be really helpful as sort of like a first defense after you've done like the regular IEP meetings. They are voluntary on both sides, so you can ask for a facilitated IEP meeting, but if the district doesn't agree to it, it's a no-go. This is where a neutral third party kind of comes in and basically just facilitates the meeting. They don't have any decision-making power. You're not gonna, separate and go back and forth like you would in mediation. They just kind of help make sure each side is getting their opportunity to talk. They can last an hour, they can be several hours. It just kind of depends on the needs of the child and the needs of the team. All required IEP team members must attend these meetings unless they are specifically excused in writing. And the goal for this is to get an updated IEP for the child. So at the facilitated IEP meetings, you can address pretty much anything that you would regularly address at a student's IEP. You can talk about special education services, occupational therapy, physical therapy, speech therapy, transportation, if you need to switch that up. If you weren't getting door-to-door transportation and now the child needs it. You can talk about the least restrictive environment for the child. You can talk about the goals. You can talk about the objectives, what's working, what's not, whether the child is still eligible for special education services. Manifestation determination reviews are always really good with a facilitator. Again, pretty much anything you would talk about at a regular IEP meeting, you can talk about at a facilitated IEP meeting. So the pros and cons. Pro, they're free. That's one of the biggest pros. Free is always good. They are minimally adversarial and they're very student-centered. You can address any concerns related to the IEP, and the team could potentially develop a plan for compensatory services. The cons, again, the school district can always say no. You can't recoup attorney's fees, but you don't necessarily need an attorney to go to this meeting with you. There is no decision made regarding alleged violations. So it's kind of a good place to start depending on the individual situation of the child. Mediation. Sarah's going to talk to you a little bit about mediation. Sarah.
Okay, so Angie's going to kind of do the process for mediation through the Colorado Department of Education, but I wanted to come up here first to sort of mention that really any of these processes you can do mediation through, and I think it is a really helpful avenue depending on the scenario. So really, while we're going to be talking about mediation with the Colorado Department of Education, please know that most of the principles that we go through also can apply to the other complaint processes that we mentioned. So there's mediation through CDE. You can request this with or without filing a complaint. So mediation without one, mediation with it. Depending on the timeline you're working with, we like to say that it's sometimes helpful to file the complaint and say you're open to mediation because you want to preserve that time. It doesn't necessarily say like, oh, you get longer to file this because you tried your hardest to resolve it without filing. They're going to just dismiss it, and you don't want that to happen. You can also do mediation with filing a due process complaint. If you file a due process complaint, we'll go a little bit more in depth on this later, but there are also what's called IDEA resolution meetings. Those are different than mediation, and we'll go through those differences a little bit later, but I wanted you to know that they exist. But basically, those are required meetings to be able to try and resolve the due process complaint before anything goes forward. You can waive that meeting if, for example, you want to go to mediation and you want to do the whole, shuttle mediation and talk through it with a third party. So just to keep in mind that those are different things. They operate kind of similarly, but they are different processes. You can do mediation with CCRD, so as Angie mentioned, that's the Colorado Civil Rights Division, so we'll talk later about complaints with them, but when I talk about that process, I want you to know that they do also offer mediation. So does the Federal Office for Civil Rights with the U.S. Department of Education, and so does the Department of Justice. Since they're operating on smaller staff, we have heard that they are really pushing for mediation, so do with that information what you will. We are going to be focusing, as I said, on mediation through the Colorado Department of Education, but just know, again, that these principles often do apply to these other complaint processes that we're also talking about, just maybe with a different link on how to request it or a different way that it comes about.
Okay, so mediation through CDE, the process and the timelines. It's available for disputes if your child has an IEP or you think your child should be eligible for an IEP. It's similar to facilitated IEP meeting, and it can be requested at any time. It can be requested after filing a state complaint or a due process complaint. It can be requested by a parent or the school district, and mediation, there's a bullet on the CDE website that kind of takes you through there. It is, oh, did you have a question?
Sorry, you keep referring to IEPs, but is that interchangeable or the same as an ILP?
Not sure I heard that, I'm sorry.
So the question was if IEP is interchangeable with ILP.
Correct.
And no, ILP is for younger students, correct? I'm not totally sure. Individualized Education Program is what IEP stands for. So for students who are K through 12, they would have an IEP. An ILP might exist outside.
Does that apply to GT students or twice exceptional students?
Does it apply to twice exceptional students? Yes, they can be eligible for an IEP. And should be and are often forgotten, so, but definitely can be eligible and should be. Did that answer your question?
Yes.
Thanks. Yes. Good question.
Yes.
My question is, at what point do you require a mediation? Because I've seen many scenarios where people usually say not yet. I mean, they're still negotiating with you. At what point is the ideal situation where you say, I need a mediation outside the county, outside the school and the district?
So the question is, at what point should you ask for mediation? Because the school is trying to negotiate with you and say, we don't need this yet, but you think you need it yet. So when do you need it? Is that correct?
Yes.
So I would say when we go through all of the more formal complaint options, what's really important is to keep the timelines in mind. So for example, a state complaint through the Colorado Department of Education, you have a year from the alleged violation to file. So I wouldn't push it off past that year so that you still retain the ability to file a complaint if you wanted to. So I think it can be helpful to negotiate with the school district no matter what, but don't let them kind of push you past any of the timelines that would be helpful. The other thing I would say that's different than from mediation versus just negotiating with the school district, and Angie will talk about this a little bit, but if you come to an agreement in mediation, you create a settlement agreement, and that's legally enforceable. The school telling you they're going to do something might not be legally enforceable. So those are kind of what I would think through when deciding whether it's time or not. But again, as Angie has said, it is voluntary. So if the school district says no, then you might need to pursue a different option.
Is that the intention of the new bill that they are proposing, is to enforce further that?
The new bill they're proposing is
to enforce that, not going beyond that timeline so that it's legally enforceable when there is a violation?
Are you talking about the civil rights bill?
Yeah.
Yeah, so essentially, I'll talk about this a little bit later too, but because some of the federal complaint options, as I mentioned, are becoming less of an option, we're trying to get those federal protections for civil rights into our state law so that they'd be enforceable at the state level. So it's not necessarily the intention to more comply with timelines, it's more the intention to have additional jurisdiction at the state level.
At the state level.
Yeah.
Gotcha.
Yeah.
Thank you.
Yes.
If they do keep kind of pushing back on the mediation, it might be helpful to request the facilitated IEP at that point. They might be more into doing that, and that might help move things along a little bit.
And then if they do a facilitated IEP meeting and, you know, it's supposed to be a kumbaya space, right? And then they, you know, the parent moves forward and the parent still doesn't feel like at the end of the day, things are being implemented as agreed upon. With the, you know, then I think it would be, I'm guessing, I'm asking a question. It would likely be more difficult for a school district to push back on mediation, correct? If they've already done the facilitated IEP or not necessarily?
I mean, it's still voluntary at that point, so I mean, if they're still pushing back,
So mediation is absolutely voluntary?
unless you've filed the complaints.
And then, so if they don't want to do mediation, you could go to a filing center.
Yes, yeah, you're correct yeah. So, but essentially what I would say is sometimes mediation can be viewed through the lens of, I'm asking for this in lieu of filing a complaint against you. And so sometimes that helps districts move a little bit more, whereas a facilitated IEP meeting might not have that same connotation.
This is interesting because I always was taught you have to do facilitation first, but I'm not hearing that.
No.
So that's what I was under the impression that we should encourage facilitation first and then mediation. That's not true.
Yeah, and it really, I mean, I think as we're going to talk about, there's lots of pros and cons to both processes. So a lot of times what I talk to families through is kind of what are your goals, what are your outcomes, and then where is the relationship at with the school district, and then see kind of what processes could be good from there. There's no harm in trying mediation, though, I would say, or facilitated IEP meeting if the school is open to that. If the family feels like they've tried everything and aren't getting anywhere, then maybe that's not, you know, a helpful step.
I was just gonna say, in like my 10 years experience, I've never seen a facilitated IEP meeting get denied. They usually accept that. I didn't even know they could deny it, actually.
I haven't either, so.
Okay.
It's a pretty.
I have, but
Have you?
yes, but not often. But I have seen it denied, and I've seen mediation denied, and it's typically if I would say the relationship with the school district and the parent has deteriorated, and the school district just says, no, we're not going to do that. You know, file a complaint, and then we'll talk to you, which is a choice. So, but typically they're open to it because they also are incentivized to resolve it on a lower level.
All right, we'll do the lady in back.
So are you all saying that facilitated IEPs as well as mediation are equivalent, or is there one that you would go to first and then one you would go to second?
I don't think you have to do one.
Can you repeat the question?
So the question is, are facilitated IEP meetings and mediation the same? Or is there one you would do before the other? So the way we've kind of structured the presentation is lower adversarial options to more adversarial options. So I would say a facilitated IEP meeting is less adversarial than mediation. In a facilitated IEP meeting, you have a meeting all together. It's just a facilitator helps make sure everything goes according to plan. Mediation, you're usually in separate rooms, and the mediator kind of goes back and forth, and you come up with that legally enforceable settlement agreement instead of an IEP. So it's a little bit more adversarial than a facilitated IEP meeting.
Yes. It costs school district, doesn't it, to do mediation? There's a cost involved, isn't there?
Mediation is, well, the mediator's free, but they would have to probably pay their attorney for that time, so there would be a cost there, yes. And they might have to pay them for the IEP meeting too. It depends if the family has an attorney. If the family has an attorney and brings that attorney to anything, the school district's also going to bring their attorney. If a child has a health plan, the hospital's going to bring their attorney. And so there's going to be a lot more voices in the room. And so that's just also something to think through.
You should also let the school district know if you have an attorney that you're bringing to the meeting with you, because they will cancel the meeting and get their attorney there, so. What was your question?
Sorry, I had two questions, but if it goes too far off tangent, please continue on. One question was, if the parents' council denies this mediation process, can that negatively affect the outcomes if they're seeking some sort of compensation or something along those lines? I heard that if the parents' council aren't agreeing to mediation, it can be looked upon very negatively when it reaches that point. But because I've had some lawyers that I work with that go to mediation. I'm like, why do you even go to mediation? Because the first thing they do is oh, you're not thinking about anything. We're done with this. And they cancel the meeting right away. And my thought was, that's probably just because they want to show that they did mediation, even though they didn't really do it. Does that make sense? Is that a thing?
It makes sense.
Yeah. I would say that makes sense, but I think it depends on the process that you're doing mediation with. For example, a more administrative complaint, like a state complaint through the Colorado Department of Education, is sometimes parents want an answer of they did this right or they did this wrong. You're not going to get that from mediation, and so sometimes parents don't want to do mediation, and if that's what they tell me, then that's, I'm going to say no to mediation in that instance. But it does, show that you're operating in good faith sometimes. But I do think, depending on what the parent really wants and what's really important to them, sometimes mediation's not always helpful.
And I guess my other one was, my understanding is there is a right within IDEA that allows you to say, if I'm not bringing my lawyer, the parent can say, if I'm not bringing my lawyer, you cannot bring your school districts. But is that mediation, or is that only for that other process that you're talking about, the resolution?
So it's only written as required in the resolution meetings under IDEA. I would say you could argue that in other processes, but it's only in those IDEA resolution meetings for due process that if the parent doesn't have an attorney, they can't bring an attorney.
Because I've seen a couple of meetings now where we do mediation because we think it's going to be great, and then they bring us a lawyer, and then they just try to hold the upper hand throughout the whole process. It doesn't feel like it's even or equal.
Yeah. The power balance is often off in these situations.
Thank you.
Yeah. Any other questions?
Okay, so I think we left off that it was voluntary on both sides. And once one party requests, the Department of Education will contact the other party to see if they're interested in doing mediation. And if everyone agrees to it, a neutral mediator will be assigned, and then they will reach out to both sides to try and schedule a time to do the mediation. It can be virtual and it can be in person, either one. So prior to mediation, everyone will sign an agreement to mediate. That includes a statement that everything in mediation has to remain confidential. It's different from the facilitated IEP meeting in a way because not everyone has to be there that is on the IEP team. At the start of mediation, the parent is usually given an opportunity to explain to everyone at the table kind of like why we're here. We usually recommend that you focus on moving forward, kind of supporting the student rather than focusing on things that have gone wrong. Like Sara was saying, usually we'll break into 2 separate rooms, and this is sort of what they refer to as shuttled mediation because the mediator will start at one side, find out what one side wants, go to the other side, and kind of go back and forth. If everyone agrees on the terms, a settlement agreement will be developed. And then if there is an impasse, a parent can pursue their kind of more formal complaint options. but still everything discussed in mediation has to remain confidential. So issues that you can address through mediation. It is available to resolve disagreements concerning special education and related services, including the identification of a child with a disability, the evaluation of a child with a disability, whether they are eligible for special education services, the development and implementation of the student's IEP, least restrictive environment, discipline, and any other matters that are protected under the Individuals with Disabilities Education Act and the Exceptional Children's Education Act, which is the state education law for Colorado. You can potentially address concerns related to the ADA in Section 504, and you should definitely do so because you will probably be asked to waive those claims as well. So the pros and cons, and again, we have the free part, that's always one of the pros. It gives the parties the power to develop settlement terms, and you can think creatively in this process. Like, for example, you can do like a summer camp or comp services for a specific behavior strategy that you might not be able to get in a full complaint process. It is less adversarial than going through a full complaint process. And then the cons, you can't recoup attorney's fees, but you don't necessarily need an attorney at this point. You have to waive all claims up to the date of that agreement, and I think Sara will talk about this more. If the settlement agreement is breached, the enforcement is through filing an action in court. Unless the terms were put into the child's IEP, then you can follow those dispute resolution procedures. There is no decision regarding an alleged violation. It is strictly confidential and usually includes a clause that you cannot even discuss the settlement agreement terms. Always good if you have kind of an older student attending, make sure that they know confidential means don't post it on social media. Another con is you may have to pay taxes if you get money as part of the settlement. So mediation through CDE. The potential remedies, you can get revisions to policies and procedures. You can get training for the school staff. This is a big one that I've seen for parents, and it's always, I don't know, it's just something, it's helpful for the staff, and then it kind of gives parents a little bit of extra. Reevaluations and functional behavioral assessments are something you can get. You can request compensatory services directly from the school district staff. You can get reimbursement for private providers, camp, therapeutic writing services, a monetary sum that you can use for services. It is not necessarily limited to what a decision maker through a complaint process would order if violations were found through a full investigation, because the district is avoiding having to go through a full investigation at that point. If you settle at mediation and that is something of value to them, like Sara was saying, because the time and resources and the money that it takes to go through this full state complaint is not as much as what you're doing on mediation. So next we have the difference between, does someone have a question? I thought I heard somebody have a question, sorry. So mediation versus the IDEA resolution meeting. So under mediation, it is available for a variety of complaints, but the IDEA resolution meeting is associated only with the due process complaint. Mediation is voluntary, but it is mandatory for the resolution meeting unless it is waived or mediation is chosen. Mediation can happen anytime, and it can be conducted by a mediator, and it can result in a written settlement agreement enforceable in state or federal court. The IDEA resolution meeting happens within 15 days of the school district receiving notice of the complaint. It's conducted by parents and the school district, and it can result in a written settlement agreement enforceable in state court, district court, or by the Colorado Department of Education. I'll hand it back over to Sara to talk about state complaints.
I will just add really quick, because actually I'm not sure I talk about it again, but when Angie was saying that the settlement agreement is enforceable, you know, in state and federal court. Really what that means is it becomes a contract claim. So you've entered into a contract with the school district, and most of these dispute resolution options aren't really applicable anymore. You need to enforce it kind of as a violation of a contract. So that can get tricky, and I'm not a contract attorney, so I would refer you elsewhere. But that's why it can get a little bit dicey there. So just to keep that in mind. Okay, so the complaint options I'm going to be talking through now are, I would say, more adversarial on the spectrum. This is, you know, when you don't want to mediate and you don't want to facilitate and you want to hold them accountable. That's, I would say, what these complaint options are best suited for. So the first option we'll discuss, and again, we'll kind of go from the less adversarial of the adversarial options to more. But the first option we're going to discuss is the state complaint process through the Colorado Department of Education. I'll just don't remember what all I had on the slide, so we'll go here while I talk about it. But this is available for disputes if your child has an IEP or you think they should be eligible for an IEP. It's also available for violations of the Protection of Students from Restraint and Seclusion Act. So that act that I was talking about that dictates how a restraint should happen, how it should be documented, how a parent should be notified. If there are violations of that act, those can also go to the Colorado Department of Education. And that's really important because when that law was first enacted, it had no teeth. It was just sort of a nice suggestion. Now they can be held accountable through this process. And so that can be really helpful when you're working with families whose children have experienced issues with restraint or seclusion at school. These complaints can be filed by anyone, so a parent can file them, an advocate can file them. Technically, a school member could file them. You can't remain anonymous when you do that, but you could do it. I can file a complaint without necessarily a student, and I have done that before. I've filed against the Colorado Department of Education with the Colorado Department of Education for their lack of doing X, Y, and Z. So these can be filed by anyone as long as they kind of follow the different procedures for state complaints. The important thing is that they have to be filed within 1 year of the alleged violation. So as we've been talking, a lot of these different complaint options have different timelines. And so it's 1 year for the state complaint process. And if you had things that have gone on past that 1 year, you can still file a complaint about it, but they're only going to go back 1 year. So if they're ordering compensatory services for something that happened, they're only going to do that violation from 1 year on. And it's 1 year from the date they receive it, not the date that you mail it. Because these do need to be mailed or hand delivered. There is no way to electronically submit these complaints. It's archaic and something that we are working on. But at this time, complaints have to be mailed or hand delivered. If you go to their office, they have a little shiny box that you put it in. But it also has to be mailed to the special education director for your district. What's great about this process and why I say you don't necessarily need an attorney for it is that you don't have to come up with legal arguments. You don't have to say, hey, the school violated, da 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 da. You can just say, the school, like, this is what happened. And their standard for opening an investigation is if the story that you tell them would lead to a potential violation, they're going to open that complaint for investigation. So you just really have to tell your story. Yes?
I know this is a little bit outside the subject, but it's within one thing that you mentioned about, do you have an easy way of explaining to a parent? Because literally I wrote an entire policy briefing a few weeks ago about this. And I cannot find an easy way to explain it to a parent. What are the most basic requirements for a violation of the Restraining and Seclusion Act?
So an easy way to explain to parents what the violations are under the Restraint and Seclusion Act. I would say the big ones for me are Well, the school is always going to try and say it didn't fit the time frame. So Colorado is really unique. We have a specific law that says there's certain documentation required under a minute, over a minute, under 5 minutes, over 5 minutes. That exists nowhere else. That is a specific Colorado thing, and it's really frustrating. So schools are going to push back on that. So it's really important, I would say, for families to document or to know how long something happened. And I think the big violation that I often see in restraint and seclusion is the documentation that gets sent to the parents. So make sure that they know what they're getting based on the incident. As far as does this restraint or seclusion incident, is it a violation? Really, the law just says, it doesn't necessarily give specifics, like they have to be held this way, or they can't do this, or they can't do that, but it would say it has to be, appropriate, or it has to be, the other word is escaping me, but so the argument would be it wasn't an appropriate restraint and it wasn't an emergency. So that would be kind of what I would have a parent look for.
So if it doesn't fall within protecting a staff or the kid itself?
So if it doesn't fall under protecting a staff member? Or a student. So that might, if they're protecting a staff member or a student, then it might be considered an emergency situation, but it has to be for imminent danger. And so that could also be a potential violation. If they're saying, oh, we just know that maybe the student was going to hit the teacher with this ruler because they said something to me 3 weeks ago about it. That's not imminent danger. You don't know if that's happening. It'd be more like a student's running towards you about to, hit you or something like that. That would be more imminent, and so that would be kind of the argument you would make there.
Thank you.
Yeah.
In this case, do they look at things like attempts at de-escalation techniques for filing a complaint?
So they look at attempts for de-escalation techniques. It depends, I would say, on a behavior intervention plan. And that's where that really comes in, because then you would be looking at they didn't follow the plan, and that would be sort of a different violation than what's required under the Restraint and Seclusion Act. Any other questions on that? Okay. Let's see what else I had on here. Oh, so you can request mediation like we've been talking about with filing or before filing. Like I mentioned, it's really important to keep this 1 year time frame in mind. If you're at 11 months and you're like, I want to try mediation first, that's great, but the 1 year timeline isn't going to extend beyond because you tried to do mediation. So I would file, say you're interested in mediation. You don't necessarily have to say you're interested in mediation. A lot of times the school will come back and say, hey, are you interested? And they'll come back to you and you can kind of make that decision then. You don't have to make it up front, but you can think about it. Process-wise, if a complaint is open for an investigation, they assign the complaint to a state complaints officer. And they are getting more of those, which is awesome. And they are all attorneys who are highly trained kind of in response to look for these violations. Yes.
So if you file a state complaint and the district comes to you and says, hey, let's try to work this out through mediation, is that state complaint still active unless you go to mediation and you resolve it?
Yes, great question. So essentially, what is the timeline if you file a state complaint, you want to do mediation, what happens with that timeline? So you do preserve your 1 year there, but essentially what happens is they'll issue an extension letter, or I forget what the official title is, but essentially they'll say the parties have agreed to try and resolve this in mediation, so we're extending our investigation timeline until this date. And so it'll extend the 60 days that they have to give you a decision. It'll extend, depending on when mediation is suggested, it'll extend the timeline the school has to return, to give a reply. It'll just kind of push it back to see if you come to an agreement in mediation. If you do, it's over and done with. If you don't, it just picks right back up again. Yes.
And maybe you will touch on this, and if that's the case, tell me. But my question is more about when there's a violation that doesn't go directly to the student, but to the parent, meaning that, and I've seen this, and I'm not gonna get into the detail because I don't wanna ask you for legal advice, but I've seen it a number of times, where the district uses legal staff to try to intimidate the parents, saying, no, IDEA says this, therefore we are acting under the law. But then I come as a non-attorney advocate, and I see the law, and I'm like, are you ridiculous? You're forgetting that the paragraph that you are citing includes a citation for 3 federal laws that says the contrary of what you're saying. What happens then when it's not directly a violation to the student? Of course, there is a violation to the student, but that's besides that specific point. The point is that they're trying to shut up the mom or the dad by using intimidation.
So essentially, a school district attorney is sort of misquoting the law, and that's confusing the parent. What do you do? So I would say, as far as state complaint processes go, or Colorado Department of Education, they only have jurisdiction over IDEA, the ECEA. They don't have jurisdiction if, say, for example, other laws cited were the ADA or Section 504. At this time, they don't. However, one of the rights that's given to you under the IDEA is to participate meaningfully as a parent. So that would go under meaningful parent participation if they are denying a parent or kind of impeding their access to different meetings or to their child's education.
Perfect, thank you.
Yeah, of course. Any other questions right now? Okay, so just process-wise, once a complaint's opened, the district gives a response. I always try and tell parents that it's their job to say that they didn't do the thing that you're accusing them of, and so it's probably going to make you angry, and so just to mentally prepare for that. But if they say anything in that's you want to refute, you don't need to say anything additional, but you can also reply to that response as well. Then they investigate, so they review the records. You can send in records, you can send in emails. There's some discrepancy right now on if emails count as records that a parent can get, and so a state complaint officer might ask for that, and they might have additional access to be able to get more things. They'll get what they need to from the school district, so don't, I don't want to file until I have these 20 documents ready to go. They'll get what they need to get, but you can provide whatever you'd like to.
I have a question about
yes.
that. Do text messages count, like, to and fro with the teacher as records, or no?
Do text messages count as records? So right now, I would say it depends who you ask. There's some dispute about that. But I would say they're records you can cite in a complaint. I've attached a text message before, yes. Okay. And as a parent, I would attach those things that they might not get from the school.
Actually, that's a very good point, because I've seen recently that some teachers and some district directors actually insist in texting or using those apps that you can basically, or they only teach you to access them through the phone, even though you can access them on the website. Technically, it's an app.
Yeah. So a lot of communication comes through an app, through text, through other devices. So I would, say to document that as much as you can, to save things as much as you can on your end. Yes.
What about recording conversations? Aren't we a single whatever state?
We are a single, I forget what it's called, but yes.
I might be a bad influence there, but recorded conversations, do those count as document?
You can provide that in filing a complaint. Single party consent. There you go.
Which is very scary, because high schoolers know that.
And a lot of high
A
schoolers
lot of high
probably
schoolers know that, and they will record things, which
Yeah,
is,
so important to think about. I would say it can kind of be different on, say you request a child's full educational file from a school, what you get might be different than, I would say, like a record that you could attach to like those can be different. So like if you have a document that maybe the school doesn't have, that doesn't mean you can't attach them to it. Okay, so they review the records, they conduct interviews, they'll talk to the teachers involved, the school staff involved, they'll talk to the parent. They want to get to know the student. They're not typically scary interviews, they're just trying to understand what happened. Within 60 days of the complaint being received, they issue a decision on whether or not violations were found. So one great thing about this process is that it's all done in 60 days. If violations are found, they'll order corrective action. I have a slide coming up that talks about what that might look like. They then monitor the corrective action, so they'll usually put a timestamp on that. They'll say, you have to get me this plan by this day, you have to have this meeting by this day. So there's an end date to all of this, and so someone will be assigned to monitor the fact that a school is implementing these things until that day. So that's the person that you would go to say, hey, they never scheduled that meeting with me. You can talk to that person for that time period. You can't appeal a complaint, so if the state complaints officer says no violations occurred, you can't appeal that. You can file due process if you're still interested in pursuing it. So what issues can you address in state complaints? Really anything that would be a violation under the IDEA or the ECEA. So child find, identification, issues with evaluations, eligibility, a student's IEP, provision of FAPE, least restrictive environment, discipline. But really what you're looking at here is procedural violations. So for example, discipline, you can't file a complaint that said, they said this wasn't a manifestation of my child's disability, but I think, they say it wasn't a manifestation, but I think it was. You can't file a complaint necessarily to overturn that. That would be something you could do in due process, which I'll talk about. But if you think that there was a violation in how the manifestation determination review occurred, then you could do that in the state complaint process. And so they might order something like making you redo that meeting. And so it could have the effect of having a new determination, but they wouldn't necessarily be able to find that in a state complaint. Concerns related to restraint and seclusion, and concerns record access, confidentiality, and staff qualifications. If a sub has been in a classroom for 6 months and your child's not receiving services from a qualified person, all of those are things that you can file a state complaint on. I know staffing issues are huge right now in our schools. It doesn't necessarily put districts off the hook from being able to implement your services. If it's in an IEP, they have to provide those services to your student. And if there is a delay, they have to make up for those services too. So important to keep in mind. Pros and cons. It's pretty quick. Most processes are not quick. This one is, and that is why I like it personally, and I think that it is very parent-friendly. They will order specific compensatory services, so they might say you get this many hours of speech services, whereas other complaint options might say, this child needs compensatory services. You should meet and decide what that is. CDE will specifically say you get this many minutes or hours of this service. There is a public decision, so all of state complaint decisions are on the Colorado Department of Education's website that anyone can look at any time. So if your desire is a public vindication of they were wrong and I was right, then you can get that potentially through a state complaint process. There's not guaranteed violation findings. There are humans going through this, so there is the human element, and you never know how they're going to come out. But if a clear violation occurred, then that would be a public decision. You can't recoup attorney's fees, but as I said, you don't necessarily need an attorney. You can file this as a parent. Again, you just have to tell your story in this process. They can't look at ADA or Section 504 at this time, but I'll talk about that. I can't address potential violations under Title 6 or 9 at this time. Again, I'll talk about that. It could become moot if a due process complaint is filed later on the same issues. All of that we'll get into a little bit more. So, potential remedies. Why would you want to file a state complaint? A state complaint, as I said, you can get kind of that right and wrong decision, whether a violation occurred or whether it didn't. You can get revisions to policies and procedures. So this is a big one. They might say, hey, school, the way that you are documenting seclusions in your district is wrong. Can you do an audit and make sure that you are doing this correctly moving forward? You can potentially get that policy revised in a state complaint decision. Training for staff. This is a big one that I see all the time. They might say violations of the right to a free and appropriate public education occurred. Please train. They might say all staff on this, or they might say the staff in this specific classroom that were part of this specific incident. You can get reevaluations or functional behavior assessments ordered. They might, just order that an IEP meeting has to occur, that kind of thing. Yes?
To get revisions in policy, and I don't know where, I can't find it, but I think you said policy or staff training. Mm-hmm. Is that individualized? Is it just directed towards your student, or can it be incorporated into like the school districts?
Yeah, so if staff training is ordered, is it specifically individual, or can it be generalized kind of within the district? Is that the question? I think it depends. I've seen them order both. And what I don't think I said in this is that you can also make systemic allegations in state complaints. So you can say, this happened to my child, but I think it's also happening to all these other kids. And so if they find a systemic violation, then they'll definitely order it for district-wide. If there is something specific, I'm trying to think of a really specific example. I think restraint and seclusion is something that sometimes can be more specific. They might say, like, this specific incident happened with these two teachers, and they need training above and beyond what we already offer. So that might be a situation that's more specific, but they have the ability to order both. Yes?
Does there have to be a clear violation for you to file a complaint?
Does there have to be a clear violation for you to file a complaint?
For them to determine if your complaint has a clear violation? Is that what we're doing here?
So you, as a parent or a person filing, you wouldn't have to say whether or not there's a clear violation. So their standard is if there could be a violation, they'll investigate it and decide whether or not there's a violation.
But they'll only go back 12 months?
Yeah, but they'll only go back 12 months. Due process, which I'll talk about, goes back 2 years. It also has its pros and cons, but this specific process only goes back 1 year. I think sometimes you can say you've had issues for longer to give that historical context, but their remedies will only go back for 1 year. Yes?
Since the state complaint results are public, can you use some of the outcomes to just show if there's a systemic issue? Like there's been 3 complaints against the district where your child is for something very similar for the last, 4 years. Are you allowed to bring that up since those are public documents?
Yes.
Oh,
and I would argue that you could also hold the State Department of Education accountable because they're supposed to be using these complaints to monitor what issues there are, and if they're not doing that, that's also their fault.
Awesome.
Yes?
I've seen a few cases like this, so I'm not going to go into the details, but there's a situation where there are occasions where students are not getting the LRE for a good reason. However, the school and the county, I forget the name, not the county, the
district?
Yes, the district is not following the therapeutic recommendations that say that this and these institutions are not appropriate, but this one is, arguing that it's more expensive. What happened in those type of cases?
So what happens if a district says that a placement for a student, they don't want to do it because it's too expensive? So a couple of things. I would say like a state complaint process, you might be able to say that's not the student's least restrictive environment. However, if you want a specific placement ordered, that would need to go through due process, which I'll talk about. I think my thought just left my head. Hold on. Let me pull it back. So I think what's the two things that I would think about are, one, they're not necessarily allowed to say this is this is a perfect place for the student, but it's too expensive, so we're not doing it. They're not allowed to use cost in that way. However, what they can say is we can provide services, the same services to this student in this other place, and so our option or our offer of FAPE is this specific place, and so then you would need to go to due process to sort of prove why your option is the better option and the better fit for that student. So unfortunately, that's kind of the only way to go. That being said, they can't just say expense, they have to say it's expensive, but we can provide the same services. So that's where the individualized piece comes really into play, is it has to be what works for that specific student.
But that is exactly what I'm saying. I have students that have even the therapist say, this is this type of place, I'm not saying this specific one.
Yeah.
I'm saying this type of place is the most, LRE for the student,
Yeah.
the most adequate. And the county or the district, more like it, comes back and says it's too expensive.
And I think your best option is kind of these dispute resolution processes. They're not supposed to rely on cost, but I think it's hard not to sometimes these days. But as long as they are offering a free and appropriate public education and they can provide services in another environment, they would likely potentially have that upper hand there.
Thank you.
Yeah. Any other questions? Okay. The last two, I don't think I talked about compensatory services, but we have talked about them before. A state complaint can order compensatory services for a violation that occurred. The last thing that is a potential remedy is a program audit. So we've only seen this once, but if you're saying like systemic violations, this is occurring, they can order an entire audit of a program to make sure that things are going well. The only time we've seen this is we filed against a state agency and they audited that entire program. And so it's not common, but it has been done. Okay, due process complaints. So a lot of pros and cons with due process complaints. So like we were talking about with state complaint processes, that's pretty parent friendly. You don't necessarily need to say these violations occurred. You just need to tell your story. It goes you pass it off to the state complaint officer. They do that investigation. That's not really how it goes with due process. With due process, you file due process, and you need to, call witnesses and have a lot of information, more like a specific court case based on what's going on. And so, yes, you get 2 years, but it's also a lot more onerous of a process than, for example, a state complaint process is. So that's, I would say, the big picture thing to think about when you're looking at Colorado Department of Education complaints. So again, it's eligible for students who are eligible for an IEP or you think they should be. It can be filed by a parent, a guardian, or an administrative unit. So a district or a BOCES can file against a parent. A situation where that might occur is, for example, they say the parent requests what's called an independent educational evaluation because they disagree with the evaluation that the school did. The school says, I think our evaluation was sufficient. They would have to take a parent to due process to prove that. So they can file against a parent. Mailed or faxed to CDE, and then also provide a copy to the district. Once the complaint's received, and again, it starts when they receive the complaint, not when you mail it. An administrative law judge or an ALJ is assigned, and then the responding party has 10 days to file a written response. Within 15 days, you have to have what we were talking about earlier, which were the resolution meetings. And so that only exists with due process, and it's mandatory. So it says, school, parent, come here and talk about this and see if we can resolve it without it going forward. And that was the process we were talking about, where if the parent doesn't have an attorney, the school district cannot bring their attorney. So then, within 30 days, there's a pre-hearing conference where they talk about logistics. So how many witnesses? Like essentially, how many days do we need? What is this going to look like? You can still request mediation after filing a due process complaint. But like I said, mediation here is different than that resolution meeting. So you say, for example, you file a due process complaint. You do want to try mediation. You could waive that resolution meeting and just go straight to mediation. Decision is issued 75 days after the complaint is filed unless the timeline is extended for a specific reason. That being said, you can appeal due process complaints, and so yes, 75 days sounds relatively quick, but it might not be that quick. It might be months or even years until you get a final resolution, kind of depending on outcome and how adversarial things are. If the complaint concerns a disciplinary change of placement, so that's those manifestation of termination reviews I was talking about, then it's called expedited due process. And so the hearing has to take place within 20 school days, and the decision must be issued within 10 school days of the hearing. So that's a lot faster. And that's really if a manifestation of termination review occurred and you disagree with it, or your student was suspended or expelled and you don't think they should be, that kind of thing, that would go to expedited due process and follow those requirements. If the school or you are not following the order of the law judge after the due process decision, you can file a state complaint to request an investigation of that. So as we were talking about those settlement agreements, you would need kind of a contract dispute, and you don't necessarily have that here. You can appeal due process. The school can also appeal due process. So either side can kind of continue appealing this to state and federal court. There's a lot of layers, and you know these cases can go up to the Supreme Court even. So you can address violations of IDEA or ECEA. The issues that I think are really good for due process are identification, evaluation, or placement. Like we were talking about, if you want your child to go to a specific school and the school district says no, then you might need to go pursue due process to say, this is why this specific placement is good for this child. You would have to call witnesses, kind of prove to the law judge why this placement is good for your child. And then the provision of FAPE. Pros and cons. So the pros of a due process complaint are it's the only process that enacts what's called the stay put provision. So if the school is trying to send your kids somewhere else and you don't want them to go there, filing due process is the only way to make them stay at the school essentially until the complaint is resolved. So it's the only process where that exists. It is a fairly quick resolution if it's not appealed and all of that. You can recuperate attorney's fees. This is a process where I would recommend having an attorney for. This is the only way to exhaust administrative remedies. So if you want to sue the school under the IDEA, you need to go through due process. First, to be able to do that, I would say the test they kind of do is if it smells like IDEA, they're going to make you exhaust. And this is the way that you would need to do that. Yes?
Is there a legal obligation by the school and or districts to inform a parent that these two last processes are available to them?
Yes, it should be in the what's it called? The procedural safeguards that they give to parents. It'll say that these are available to them.
But there's no, like, beyond that, because that obviously a lot of parents miss that because that's just, oh, know your rights, right? But a lot of parents are like, well, I don't understand all that language. Is there an obligation beyond just the written statements?
That's a great question. I'm not totally sure the answer to, so.
Okay.
But I can look into that if you'd like.
Yes, please.
Okay.
Thank you.
Yes.
So for due process complaints, I would never recommend this, but parents can go to this without an attorney, right? But if they really fumbled the ball, like the school district could probably even seek damages for wasting their time and things along those lines, right?
Yeah, yeah. So I mean, that's a big con of the process, right? Is you don't want to just file it frivolously, but yeah, you don't need I think I phrased that. You aren't required to have an attorney for this process. I would highly recommend against trying to do it pro se. I do find in some other processes, like mediation, for example, mediators are great with parents who are pro se. That's not always the case with administrative law judges, and so it can really be a gamble that might likely hurt you more than it would help you. Any other questions? Okay. Cons, it can address systemic issues. So our office doesn't really do due process because most of the outcomes are for individual children based on that individual child. And like Angie said at the beginning, we're really focused on systemic work because we are a statewide organization. And so because this process can be so onerous, it's not, and you can't get systemic remedies, it's not always a process that we kind of look into. You can't address those intersectional issues. You probably need an attorney, as we were talking about, and it really is an administrative court proceeding. So you have to submit evidence. You have to really kind of think through being able to prove your side of the case. It is a very adversarial process, but you can, as we were saying, be ordered to pay the district attorney's fees. So if it was frivolous, they could seek attorney's fees, and that could be something that you are ordered to pay. So it can be a helpful process for the right situation, but it can also, that's kind of why we like to do this, because there are a lot of different processes that are more helpful than this specific process, and this is often the process that most parents know about. Yes.
So, it's going to be a date. Do you have a sense of the quality of the ALJs that are doing these? And it's not a gaudy question, it's just depending on the kind of area, they can really vary. They can be very experienced, like work in Medicaid. You deal with Medicaid ALJs who know nothing about Medicaid. I'm wondering if this is the same situation here.
There's not necessarily a requirement to know the intricacies of these laws, and so take that for what you will. I would say broadly, in my experience or data that I have heard, parents win closer to 10% of the time.
Okay.
Yes.
That's kind of my question. How often have parents won these in the last 6 years?
How often have parents won these? So the last data I got is a few years old, but it was about 10%.
I said, because I read a newspaper article, like it was over a year ago, about Academy District 20 or something, where a case was won, and they said it was the second one since 2018 where they found in favor of the parents.
Yeah. Yeah, so it is, I would say, fewer and far between that it's found in favor of the parents.
Wow, because they bring an attorney.
Which agency, though, are you talking about?
Which agency?
Yeah, are you talking about CDE or Department of Justice? Which agency?
So these are administrative law judges, so they're separate essentially from the agency.
Oh, is this mediation?
Mediation would be through, those are employees of the Colorado Department of Education, well, contractors. Did you have a question?
I was just going to say, sitting on the other side of the table as a psych, I used to work in the districts as a psych. Sometimes you're telling these judges of how these processes work, and they just kind of run with your understanding of it, is from what I've seen. So it's really hard if you don't have an expert on the other side to understand what was even said behind those closed doors. Because my interpretation and my understanding of things can be what they run with.
Very intimidating, I know. Okay, but the remedies you can get: ordering of compensatory services, tuition reimbursement. So if you want tuition reimbursement for sending your child to a private school, this would be the way to do it. You want a specific placement order, this would be the way to do it.
I have a quick question.
Yes.
So if you want like reimbursement or a placement somewhere else, does that take years of like data of the kid not progressing? Do you have to have like years worth of that kind of data to say, I want another placement in another school, in private school?
There's no requirement to have years of data, but it would help.
Okay.
Yeah.
So by that time, the kid will already be far behind.
Well, I think that's when you would go, to the IEP meeting or maybe do a lower level process. You don't necessarily you have to go through this process to get a specific placement, but you don't necessarily have to go to this process to ask the IEP team for a new placement. If you think things aren't working and you have that data, just talk to the IEP team and they might be able to change the placement, or you could, pursue reevaluation or get an independent evaluation to kind of reassess placement. You don't have to go through that process for that.
Okay.
Yes.
So if you go through, let's say, mediation and everybody agrees, and then after mediation, still things are not resolving, will either a state complaint or this process, or due process, will they take into consideration those past things that you've been doing if it happened within the last 2 years?
Yeah, so the timeline still is the 2 years.
Would they take, with the state complaint, well, that's 1 year, but the due process, they would take into consideration parent district attempted, they would resolve, the fact that the parent was attempting to work with the district and still things did not resolve. Is that in any way strengthen the validity of going to something like this?
It could, as long as it doesn't. Yeah, I think it could, but not going beyond that 2 years. So I think with all of these processes, they get a lot of complaints, and so even if you have a very compelling complaint, they don't often care. They just want to, doesn't fit, dismiss. And so it could be helpful, I would say, but not if it makes it go beyond the 2 years. And because we are running a little bit low on time, I'm going to skip and come back to this section because it will make more sense shortly. Okay, so we've had a lot of changes at the federal level. So previously, if something, a violation of Section 504 or Title VI, the Civil Rights Act, or race, gender, disability discrimination occurred that wasn't specific to a student's IEP or the IDEA, you would file that with the Office for Civil Rights in the U.S. Department of Education or the Department of Justice. As we've alluded to, they've had a lot of staffing changes, so they are pretty much operating on a skeleton crew. A lot of people have been reassigned to other places, so they're not necessarily investigating complaints or pursuing remedies at the level that they were before. So that's why we have that CCRD process, that's Colorado Civil Rights Division. That's why we have that process in there, is because I would say that they aren't as familiar with education issues from my experience. However, they are starting to have to become familiar with education issues because that is the place that people are more likely to go now because they can't necessarily go to the federal government. So they are taking some complaints from what we've heard. I would say disability discrimination specifically, they are taking some of those cases. As Angie said, we do still recommend a record of filing. What we don't want is them to say, you know, we're going to eliminate the Office for Civil Rights entirely because no one's filing complaints, so why do we need it? So it's still important to file, just know that you might not hear back. As I also said, we've heard they're doing more mediation to kind of try and push through some things. You might hear back and it might be great and you might not, so just have that kind of knowledge. What to look for and expect, again, delays, lack of response. What's the most important bullet on this slide is to maintain your legal expectations. So while these mechanisms may not be as active, the law hasn't changed. So the civil rights that your student has or that your classroom has still exist and still should be upheld. There just might be less avenues to pursue remedies for that. So that's really important to think about. What we're really looking at, as I alluded to, is the state level changes. So we're looking at putting civil rights protections for students into our state law. And that's happening this legislative session. So if that's something you're interested in, probably all hands on deck, definitely let us know. But essentially what that would look like is I would say a lot of issues are already intersectional. So say, for example, a school district didn't implement a student's behavior plan properly and there was an issue there, but then also that student was bullied. You would have to historically file two separate complaints, one about the behavior plan and one about the bullying. So the goal here would be to be able to file all of that into one place. So a lot of our state complaint officers are already trained to look for these things, but then they have to give them over to the Office for Civil Rights. So this would essentially just allow them to look at things in a kind of intersectional lens. So that's really what we're looking for. I think the other important piece, when we talk about the Colorado Civil Rights Division, is that, like I said, they aren't as familiar with education issues, and so this would let the people who are familiar with education issues be the people that look at education issues. So that's something coming through this legislative session if you want to keep your eye on it, or we'll take all the support we can get. That's kind of where I would say on those federal changes. I'll go through quickly kind of the time frames. We only have a few more minutes, so I don't want to spend a ton of time on processes that aren't going to be super helpful to you right now, but I want you to know that they exist. So, CCRD complaints. Oh gosh. So, again, these slides, you will have them. We also, if you're not tired of hearing me talk, I do have a video where I talk through all of these processes on our YouTube channel. It was recorded before there were changes at the federal level, so if you do listen to that, take that into account, as they might not be as effective at this time. What's important? Yes?
Where do we access the slides on the YouTube channel?
We will send the slides to registrants, correct? With a recording, and the slides have a link to the video in them. It's also on our website. If you search YouTube, Disability Law Colorado, it'll probably come up too. I would say this is CCRD civil rights. What's really important is you only have 60 days. 60 calendar days. And that includes doing an intake with their office to see if you can even file, and then filing something. It has to be signed within 60 days. That's a really tight turnaround. So if you have experienced a civil rights violation, look at it kind of immediately. I'm going to go kind of through these options. OCR is 180 days. So again, we're looking at civil rights discrimination. So based on disability, gender, race. You have 180 calendar days. They are not lenient on that 180 days. The Department of Justice, another complaint option. They don't necessarily have that limitation. What I will say about both of these processes is that, like we talked about with state complaint, you have 60 days, you get a decision. That doesn't exist for OCR and DOJ. OCR, I would say, can be quicker. The Department of Justice sometimes we haven't heard back from them for 3 years. And then they might do a lot of things about the thing that you complained about to them about. And it can be really awesome, but if you need an immediate resolution, these probably aren't the best processes. However, keep these timelines in mind because they're really important. The difference between the federal options and the state options is that you don't necessarily have to do the mail hand-delivered thing. You could write what happened on a hotel napkin and throw it at them. You can email it to them. They take complaints in a variety of ways, and so that can be really helpful as well. That's kind of my high-level overview of that. The last thing I want to be sure to talk about is just lawsuits. The summary of this is if you're considering a lawsuit against a school or district, call a lawyer. There are a lot of exhaustion requirements, a lot of notification requirements, and you want to be sure that you're meeting those. So, like we said, exhaustion can be required if it even smells like IDEA. If the school violated, you think, the Americans with Disabilities Act or Section 504, but maybe it could have been IDEA related-ish, they're going to make you exhaust. So consult an attorney, go through the requisite processes if that's something that you're looking for. That's all I've got today, but the slides, the videos are linked there. So we have it in English and Spanish. And we also have our fact sheet. So that education resource guide that we have over there is also online if you would like to just do a PDF and Control F and find specifically what you're looking for instead of reading the paper. It's also there for you. There's Angie and I's email, a QR code if you want to support our work. But yeah, I'll be here for a little bit, so feel free to come ask questions. But thank you for your attention today.